Our next case is Malcolm Page and another versus the Massachusetts Department of Environmental Protection and another. As council approaches, we did allow the motion to substitute, but the case is still captioned this way. So for today's purposes, that's why I'm calling it. And I just want to make sure, Mr. McKay, you are 10 minutes, and Mr. Hitt, you are 5 minutes. Is that correct? Mr. Silverstein, when you are ready.
Thank you, Your Honor. May it please the Court, Jonathan Silverstein for the plaintiffs' appellants, Malcolm Page and Jill Stickler Page. Your Honor, the primary issue in this case is one of due process and fairness.
I thought you were going to say standing.
Well, yes.
We don't get to those if there's no standing.
Well, and the standing issue is based upon a fundamentally unfair process to which the Pages were subjected.
Well, you're way ahead of me, so let's dial it back.
Fair enough.
I'm a simple person. I start reading your brief, and I think, oh, my God, this is on top of each other. This is outrageous. And then I finish reading your brief, and I read your brother's briefs. And it's not quite as it's described. So I want to understand from you. I understand, I think, the geography of the dock, but it seems to me that the question about your client's injuries, my question is, why is that not speculative? They have no plans to do anything now. In fact, they have something else that's on the other side of the property. So before we get to all, the fundamental fairness questions and the due process questions, we have this basic question of standing, whether or not they're a person aggrieved. And I need you to help me with that.
Sure. So I will help you with that, Your Honor. And I think it's also important to recognize that they were never given the opportunity to present evidence on that. But backing up, the issue is they're entitled to fair and safe navigation proximate to their property line. When you have speedboats zooming up to a dock 1 foot from your property line and your children or invitees are swimming next to your property and have to jump out of the way, I would say that that is a cognizable injury. There's a reason for this 25-foot setback requirement, and it is on its face a problem. Moreover, they submitted expert testimony and testimony of Mr. Page that identified that this would be a problem. And, Your Honor, I would submit that if someone builds something 1 foot from my property line which deprives me of any future ability to put something within 50 feet of that, I think that's an injury whether or not I have a present intent or plan to put something there.
Is it true that your clients access their property from the other side?
It is true that they presently have another dock that is not within 25 feet of their property line, but they also have the right to improve their property, and they have the right to have their family and guests safely enjoy the water in front of their property, rather than having
dock interfere with your client's private access if they have private access on the other side?
Because they have a right to private access where they want to put it, Your Honor. And they have a right to enjoy their water in front of their property and not have some. When you have a dock 1 foot from the property line, if a boat comes in and docks there, it's in front of your property line. It's a 10, 12-foot wide boat, motorized, coming in preventing you from enjoying your waterfront.
What says they can dock on the other side of the dock as opposed to the side that's on their side of the property line?
They could, but they don't have to. So now we have to rely on the property owner next door to be a good neighbor and choose to dock on the other side? Or what if they have two motorboats, and they decide to put one on either side? The point here, Your Honor, and I really think it's important, is that my clients were never given an opportunity to provide evidence of standing.
So you say, on page 18 of your brief, you say that this post-PHC orders caution the parties they should not include information not relevant to these specifically identified issues. I can't figure out what the specifically identified issues are.
Well, I identify it. So on September 22nd, 2021, OADR, the Office of Appeals and Dispute Resolution, issued an order. This was after a pre-hearing conference.
Right.
Issued an order, and in that order there were two issues identified. Is it feasible to place the dock 12 feet away from the property line? And is the proposed location the only feasible location? No issue of standing was raised at the conference. In the OADR order that identified what the issues were that the pages had to provide pre-file testimony on. Instead, after the case was fully submitted with pre-file testimony, for the first time, DEP in January of the following year moves to dismiss.
But it's standing.
Absolutely. I'm not saying that standing is subject matter jurisdiction. I'm not saying that it couldn't be raised.
And not only is it subject matter jurisdiction, but it's something that every single lawyer knows is a sine qua non of being able to appear in and maintain a lawsuit.
Absolutely, Your Honor. So a couple issues. First of all, the pages were self-represented originally. I only came in on the appeal.
When Mr. Page filed his pre-filed direct testimony?
Well, so again, yes, standing is an issue that everyone knows.
Was that a yes in response to my question, or
was he represented at the time? Yes, I believe by the time it got to OADR, the pages had counsel. But respectfully, I would submit that when you show up to a conference, when you get an OADR order that says these are the issues, these are the only issues, and their rules say you can't address any other issues, DEP hasn't raised standing. No one has raised standing. For the first time, after all the pre-filed testimony is submitted, a motion to dismiss on standing is filed, and you get a show cause order that says you may not submit any additional evidence.
Right, but I think their argument is that that should have been in the original pre-filed testimony.
But respectfully, I would say that when no one has raised the issue, either the hearing officer or two represented other parties, I submit you don't have to raise standing if no one has challenged it.
On May 28th, 2021, the DEP sent a letter to, at the time, Ballas, with the draft license. This is at record, I think it's 6, page 146 or 83. It's hard to say how this was. And it says specifically, what information must be included in your hearing request? E, if claiming to be a person aggrieved, the specific facts that demonstrate the party satisfies the definition of aggrieved person found in the CMR. That's in May of 2021. The DEP flagged that it might be a form letter, but it includes this question of standing. But
what it doesn't say is you have to present your expert and pre-filed testimony. You have to identify standing, and I'd submit they did identify standing. What they didn't do was prove it. That's
a different question. First, you're saying they didn't know standing was at issue.
Nope.
We have a letter from the DEP saying, hey, we're going to allow this. If you want to appeal, here are the myriad things you have to do, one of which is if you're claiming to be a person aggrieved, you have to demonstrate that.
Right.
I don't think the DEP has to tell them how. That's why they have lawyers. Now you're saying they didn't get the chance to do it. So those are two separate
It's
questions.
a difference, Your Honor, between pleading and proof.
Agreed.
And they pled standing. They
Who
were
are they in that sentence? I just want
the
to
pages.
Okay.
The issue isn't that the motion to dismiss is based on DEP's expert testimony. The motion to dismiss was allowed based upon DEP's expert testimony. None of that was available to the pages when they filed their request for adjudicatory hearing.
So where's their pleading of standing?
I'm sorry?
Where did they plead standing?
In their original, I don't have the cite to their original appeal, Your Honor, in the record, but that's not the basis of the decision that they lack standing. The basis of their decision that they lack standing is that their pre-filed testimony, which only gets filed after the initial conference and can only address the issues identified in the OADR order, which did not include standing. So, yeah, standing theoretically is an issue in every case, but it's like saying that you try a case, no one raises standing, you're not given an opportunity to cross-examine witnesses, you're not given an opportunity to submit evidence after the issue of standing is raised for the first time in this adjudicatory proceeding. Your Honor, what you cited to was the original issuance of the license by DEP to Velas, to the property owner. So the notion that you show up to a conference, no one raises standing. You're issued an order saying, submit pre-filed testimony based on these two issues, which does not include standing. And OADR's own orders say you can only DEP regulations say you can only address the issues identified in the pre-hearing order from OADR.
Do you agree that the Waterways Act does not give abutters special status for purposes of standing the way other standing works? You know, sometimes if you're within 300 feet, you're automatic standing. The Waterway Act in and of itself, as I understand the Higgins case, says abutters do not receive special status for purposes of standing. And if that's true, aren't your clients sort of on notice in that way that they have to prove standing? Because
the fact that there's no presumption of standing doesn't mean that there isn't a due process problem when you're told by the hearing officer you can only address these two issues in your pre-filed testimony. And then after you submit your pre-filed testimony, a third issue is raised and you're prohibited from submitting additional testimony. You're prevented from cross-examining witnesses. This is a matter of process, Your Honor. Sure, standing can be an issue. Rightness can be an issue. Any number of subject matter jurisdictions are always on the table. But the question is, when you are given an order and you follow that order, and then you're told because you didn't submit something that you were prohibited from submitting under that order that you've lost your ability to address that issue, that is fundamentally unfair.
So the standing assessment requires that a showing that the plaintiffs are persons aggrieved who may suffer an injury that is different in kind or magnitude from that suffered by the general public.
May suffer.
And
which is different, by the way, from 40A-17 standing where you have to show you will be harmed.
Right. As I read the pre-filed direct testimony of Malcolm Page, it addresses the water levels, the rocks, and concerns about boats hitting the rocks, and seems primarily focused on what Mr. Page identifies as the possibility for safely situating the floating dock in a different location. Obviously not on his own property, on the defendant's property. in that submission speaks to the injury that the pages will suffer?
It doesn't, because he wasn't put on notice he needed to in the pre-filed testimony.
Well,
the pre-filed testimony order said you can only address these two issues.
Blake identified a letter that was filed in November of 2021, that direct testimony, and there was a letter that was sent in May of that same year saying standing needed to be established.
That was from the licensing officials. This is the problem when you have DEP as an umbrella organization. That reference was to the original issuance of the license to the VLISs, not to the pages. And that was the license that triggered the appeal to OADR. So then it's like saying a zoning board of appeals issues a special permit that says a person aggrieved can appeal. And then you go to court and the judge says, I don't want to hear anything about standing. I only want to hear about these two issues. And you brief those two issues, and then the judge says, well, you didn't provide evidence of standing, so I'm dismissing the case. That's what happened here.
Let me just
the OADR proceeding was
Counsel,
after.
I have to pause you because your time has expired. I just want to see if the panel has any other questions. Seeing none, we're going to have to take the rest of the argument on brief. Thank you. Mr. McKay for the substituted parties, correct?
Yes, Your Honor. Good morning, Justices. My name is Dave McKay. I represent Drs. Bateman and Salerno, who purchased the property from Mr. Vallis, who was the original applicant.
With this litigation pending?
With this litigation pending, Your Honor. And I'll start with that. This case has been pending in one form or another for almost 5 years, that Mr. Vallis applied for a dock license and got it. My brother...
Is the dock there?
Pardon me?
Did he build the dock?
No, the dock has not been built because of the risk associated with the appeals. So the dock hasn't been built. There is a pre-existing dock there, and as is in the record, Mr. Vallis had problems with that navigating safely, which is ultimately what led to this application. This application has been through several layers of review, as the Court is no doubt aware. It began with an order of conditions from the Conservation Commission in the town of Hopkinton. Then it went to DEP.
I actually advance you a little bit forward because Mr. Silverstein makes a very impassioned plea about, sure, standing is subject matter jurisdiction which can be raised any time, but how is it fair that after the fact the department comes in, and maybe I'll ask this of Mr. Hitt, comes in after everything has been presented and says, oh yeah, by the way, now you need to dismiss this because there's no standing. How is that fair?
Because the pages were on notice of standing as an issue from the very beginning.
How?
In the original cover letter, as Your Honor pointed out.
But they're simply CC'd on that letter.
Right, but they were CC'd on the letter. That's the transmittal letter that went to Mr. Vallis granting the draft license. But it also is directed to, it's not addressed to, but it is directed and provides instructions for how to appeal and indicates in that cover letter that a party that wishes to appeal the permit must include specific facts that demonstrate that the parties are satisfied the definition of an aggrieved person. That's not the only instruction to the petitioners, however. In the scheduling order, there is another instruction. So this is after the pages filed their appeal. It's on page 105 of volume 1 of the record appendix. Footnote 2 indicates that the presiding officer may recommend dismissal on various grounds, including lack of standing. And I think it goes to the Court's point at the beginning, which is lawyers and parties are always on notice and required to establish standing. That is one of the threshold issues to maintain an appeal in a case like this. They were on notice of that. They had the opportunity to present it. It's also worth noting that
Well, wait, I want to stop you on that second piece because your brother says whether or not they were on notice of it, they were told you may present only the things on this list and nothing more. Is that Do you disagree with that factual assertion?
I do disagree with that. Those were the issues that were identified for adjudication, but underlying that is always the underlying jurisdictional issue that you have to present evidence of standing. And I would submit that the Pages attempted to do that in their pre-filed testimony. They attempted to show that the dock could be moved, and they referenced the issue of their potential future plans, which we don't think rise to the level of something that can provide standing, speculative potential plans for a dock by the property line when they have alternate access. But they did present those issues. I don't think that they can make the credible claim that they weren't on notice of the standing issue. They were on notice of it in writing at least twice. And it is an underlying threshold jurisdictional issue always. And the Pages were represented by counsel. I mean, I don't think that this was a surprise issue. A couple of other things that I would like to point out in the limited time that I have available. In addition to it's worth noting that the underlying standard of review here is highly deferential to the agency. This is an issue that DEP deals with all the time. Standing is slightly different in the context of a waterways license than it is in other aspects. The DEP has dealt with this. There was no evidence in the record of the kind of safety issue that my brother counsel pointed to with respect to that putting the dock in this location would be unsafe for the Pages or for their visitors or anything like that. In fact, the evidence in the record that is not controverted shows that this was an area that the only thing that they had indicated they were actually doing was landscaping that area. It's not an area that's used for access to the waterfront, and this goes to the whole policy behind how the department deals with waterway license issues. And it goes both to the standing question, it also goes to the issue of whether there is a significant interference, which is a separate and independent basis upon which, although the Superior Court didn't reference this, the hearing officer at Mass DEP could, and I would submit that that is also a basis upon which this court could also dismiss the appeal. The issue with respect to standing and the alternate access was that there was no evidence of unsafe access for the Pages, and in fact, the record showed that they had another dock 130 feet away that provided them with all of the access that they needed.
What about his comment that your client could park the boat on either side of the dock?
I suppose that's possible, but that does not open the door, nor does it create some broader property right that the Pages would have to interfere with that.
I think you're saying it means they can't use their water access for fear that if your clients come up with a boat on that side, they could literally kill the property owner or their guests.
There are two issues with that. The first is it's speculative in that they had no plans to build such a dock.
Not dock. They just want to swim. They want to get in the water on their property, from their property, and they're saying now their life and limb is at risk because your client somehow has the right to park on both sides.
Well, they're saying that now. I don't think that kind of a safety issue, access for swimming or so forth, was an issue that was raised at Mass DEP. But second, that is not what Chapter 91 provides and within the scope of the protections that Chapter 91 provides. It is not a blanket, I get to do everything that I want to do on the waterfront. It is a balancing of the rights of multiple parties to access the waterfront. And in this instance, there was a significant safety issue for Vallis that required the location of the dock to be closer. And so the analysis that DEP goes through and the analysis that the law requires is, will that significantly interfere with the Pages' right to access the water from their property? And it was unequivocal that it didn't. That was not a disputed fact. They had their dock. They had plenty of access
Access by some sort of watercraft, but does it address the issue of just swimming off of their property?
Yes, because it's a similar right. It's not a right to, I mean, by that measure, any dock anywhere would interfere with someone's ability to access the water. The question here is a balancing of the interests.
Well, no, it's because this dock is so close to the property line. If it were the 25-foot set-off or even the 12-foot set-off, it wouldn't interfere with, I've forgotten all the names, but the complaining parties.
Yes, it would not interfere with the Page's ability to access the water, and they can swim just like they can use their dock for boat access, they can use their dock for water access. I would also add that there's nothing in the record that suggests
not their
that
dock,
they were...
They just want to walk from their property into the water. I mean, it seems like your guy would be entirely foolish to dock on the other side. That would be very provocative, but maybe he has the legal right. That doesn't always mean people should exercise it. But it seems like he would risk liability if he comes on that side. But they're just saying, I want to walk off of my property into this lake. Even if I don't have a dock, I just want to walk. I want to be on my property, and I want to walk into the water, and that your client's dock makes that not happen. So why wouldn't that give him standing?
Because the way the dock was designed was not for that purpose. It's a U-shaped dock with a boat lift. So you pull the boat in on the Vallis side, or now the Bateman-Salerno side of the property. There's a plan of the proposed dock in the record, and I'm just going to get, Your Honor, the page reference. It is page 169 of volume 1 of the record appendix. And so if you're looking at from the water at the Vallis property to the far left, so farthest from the Page's property line is the location of where the jet skis would be, and then it's a U-shaped dock directly next to that is close to the property line. But the dock is designed that the boat goes in between the U-shaped dock, not to the right where the Page's property would be. So their access to the property.
And your time has expired. So Justice Henry's question.
I just want to understand the timing, because the scheduling order that has footnote 2 in it, that order is issued on August 19, 2021, and then this order that says brief these two issues is a month later, September 22, 2021. So when is it that his clients were supposed to put in their evidence of standing?
With their pre-filed testimony, which is an underlying jurisdictional requirement for every plaintiff in that kind of an appeal.
In response to or after the order that's on, that includes Record Appendix 196, that's after the... It starts the I love this title, post-pre-hearing conference that starts on 190 that says only brief these two issues.
Yes.
They're supposed to ignore that and put in their standing.
Not at all. It's a threshold question. So they're addressing the substantive issues, but they're also addressing their jurisdictional requirement to establish standing, which, frankly, I don't think was all that different from the evidence that they did put in their pre-filed testimony. I don't think that they were deprived of any opportunity, and they knew, or they should have known all along, that standing was always an issue.
Thank you. Mr.
Thank you, Your Honors.
May it please the Court, Assistant Attorney General John Hitt for the Department. The process here was not fair in any respect. There was ample notice that standing was something that had to be established.
I think you just said the process was not fair.
That's what I thought I heard.
Unfair.
No, the process, there's no merit to the fact that the process, there was adequate process in terms of raising the standing issue.
What about this idea that you...
Sorry if I misspoke. I'm sorry, Your Honor.
No, that's okay. We're awake for sure now. What about his argument that there's this scheduling order on August 19th that drops this little footnote, which is a serious, tiny footnote on a huge issue, And then there's this order on September 22nd that says brief these 2 issues and nothing else.
So, Your Honor, that's going to the issue of what would be the briefing on the merits were they to reach the merits. After the pre-filed testimony is submitted.
No, where does it say that? Because I'm kind of what's a basic person? I know that these people had counsel, but where is the regular average person supposed to understand that they got to put in standing?
Sure. So
like with a giant flag so that everybody says this is fair, because that's what government should be doing. And there's a reason why half the country wants to overthrow the government, right? Maybe you agree, maybe you don't agree, but there's a real issue about government being for people who have money and who understand things and not for regular people. So where in here, in this record, with page numbers, does this say, warning sign, you got to put this evidence in?
So, Your Honor, when the draft license is originally issued, as Chief Justice Blake noted, there's a cover letter that comes with it that was also delivered to the abutters that very clearly indicates that standing is an issue if they want to try and challenge the issue of the draft license. So that's location number 1. Location number 2 is the pre-existing case law.
When are they supposed to put it in, right? Because when you get to 196, it says 2 issues, and it does not say standing.
Again, Your Honor, that writing by the hearing officer is laying out what will be the substantive issues if the case is reached on the merits.
Yeah, but a lot of people, I'm a good little rule follower. Many judges are, right? So I get to that pleading, and it says these 2 issues, and it's 196, not 199, so that threw me. But when you get to 196, it says these 2 issues. They even sets them out, 1 and 2. Where does it say in this thing? But by the way, you should definitely cover standing.
Okay, Your Honor, in that decision itself, in the hearing officer's order, it does not specifically discuss standing. It does highlight the 2 substantive issues that will be briefed if the case is reached on the merits. There's also another.
Why does that not seem unfair to you?
Because there's a regulation, 310 CMR 1.01 11E, which clearly says that at a later stage in the administrative proceeding, that issues such as this can be raised, and that's exactly what the department does here. So they file a motion to dismiss. There's then ample process.
Like a gotcha. I mean, you get, most of the time when you get into some sort of administrative hearing, it does have this long letter with which might be your original letter, but then each time it goes through the process and explains what your options are. And here we get to 196 and it's like 2 issues. That's it.
Your Honor, this is an adjudicatory proceeding like any other adjudicatory proceeding. If you're in court, standing is always an issue, and it can be raised at any point in the proceeding. So what the department does here is completely consistent with their usual process, which is to raise it by way of a motion to dismiss, which is served on the pages. They get notice that standing is being raised. Administrative Record, Volume 3, page 17 is the motion to dismiss. You can then follow along through basically in the next 100 pages of the administrative record while there is extensive briefing back and forth on the standing issue.
That's briefing, right? I mean, the essence of a motion to dismiss is that it essentially closes the factual submissions on an issue, right?
But, Your Honor, at no point do the pages attempt to submit any sort of evidence beyond their evidence on the merits on the issue of standing. So there's briefing by the department. There's an opposition by the pages. There's a reply by the department. Then there's a notice from the hearing officer who says, you know what? Standing is an issue. I sua sponte am issuing this order to show cause on why I shouldn't dismiss this case, for reason of standing. That's exactly the process that's being provided that's fair to the pages. They are on clear notice.
And in response to the notice to show cause, or the order to show cause, were the pages allowed to submit additional factual material.
They were not prohibited from doing it. They made no attempt to submit any additional factual information. They relied on their factual submission in the pre-filed testimony. There are ample submissions in the record that show that there was adequate process to meet due process requirements, and that this was not an unfairly raised issue. So, standing is very clear. When you get...
Your time has expired. I just need to see if the panel has additional questions. Seeing none, we're going to have to take the rest of the arguments on your brief. Thank you all. Very well argued case. It is under advisement. The court is going to take about a 10-minute morning recess. When we return, we will start with the Paul Fiore DeFarias versus City of Gloucester case.